Good evening. I'm Yvonne Okwara Matole. Our big story tonight, the Jubilee Party presents the Electoral Amendment Bill 2017 and does so in a record one day, courtesy of their numbers in both the National Assembly and the Senate. Meanwhile, the National Super Alliance Coalition representatives walked out of the IEBC talks in protest against the amendments tabled by Jubilee. NASA accuses Jubilee of infringing on the independence of the Electoral Commission, while Jubilee insists they are sealing loopholes in the law. Are we looking at a stalemate ahead of the poll? And will the IEBC talks break the deadlock? That is our big story tonight, and we will be focusing on a number of angles tonight. I want to ask you to join us in this discussion on the amendments. We have our lead reporter, Sophia Wanuna, who will be speaking, or has spoken a short while ago, to Aden Duale, who's a majority leader in the National Assembly. We'll be getting to hear more on that. But also tonight we'll be speaking with a member of National Assembly, Otiende Amolo. He'll be joining me to have some reactions to what happened in Parliament today and what happened at the Bomas of Kenya. But first, our lead reporter, Sophia Wanuna. Sophia, what a day it's been. Everything you said yesterday finally came to pass. These amendments were tabled on the floor of the House today. Tell us what happened thereafter.
Good evening, Yvonne. Indeed, what we talked about yesterday coming to pass today here at the Parliament buildings in chambers. The Leader of Majority, Aden Duale, in the National Assembly tabling that bill, and I'm holding it here. It is the Election Laws Amendment Bill 2017. And one of the orders of business, once it was tabled, we saw, because usually there's a period of 14 days for a bill for publication of the same to happen, was a motion to be able to reduce that period of time from 14 days to 1 day, Yvonne. And there was debate around that. Members from the National Super Alliance in the National Assembly opposed to that change. However, they have the numbers in the Jubilee party, so they carried the day, and that motion passed 1 day for the publication of this bill. And we just spoke to the Leader of Majority a short moment ago, and we will get to hear what he has to say, especially in regard to some of those assertions and claims we've heard coming from the National Super Alliance in regard to this bill coming at this time, just under a month to the repeat presidential poll. But perhaps if you want to just mention what will happen here on out is that today also the first reading of this bill took place, and the members of the National Assembly have now gone on recess for 11 days. So what will be happening in this period of time is an ad hoc committee will be formed, and National Super Alliance had indicated they did not want to be part of any committee, but the Leader of Majority mentioning to me that even if they choose not to participate, that committee will still be put in place and will be able to legally operate even without those who may not wish to be part of it. So after this recess, what will be happening in that period of time is public participation, and we understand it will be conducted by both houses. They'll have a joint seating for the public participation to save on time, is what we're hearing. So the National Assembly as well as the Senate. And after the public participation, when they return, then they will have the second reading. This is about the 10th of next month. And if there are any amendments, it may go to the third reading. But after it's conclusively conversed here at the National Assembly, it will then be taken to the Senate, where the same processes will follow, and then back to the National Assembly if it's successful, and after that to the President. And according to those in Jubilee, they say this should be one that will move really fast because of the numbers they have working for them, Yvonne.
Yeah, and that was what I was going to ask you, because obviously there's been an idea of speed with this bill, considering that its publication was reduced to just 1 day from 14. And that's the sort of pace we expect when the House reconvenes with this, and that's what you're telling us, right?
Yeah, some real expediency at its best is what we will be seeing once members resume from this 11-day recess. They are confident that all readings and all other amendments and anything thereafter in the National Assembly should be able to take place even in a day, and then to the Senate and back to the National Assembly, so that even 3 days could be sufficient to have this as law and gazetted, assented to by the President and gazetted. So we're definitely going to be seeing things working really fast. And it's a lot of what also we've been seeing Kenyans on social media weighing in on how when members have got their eyes trained on a matter that they deem and see as very important to them, things move really
that's
fast.
right. Yes, and we will definitely get to hear from the Member of Parliament, Otiende Amolo, on all of these. But it's important to remind our viewers that you are reporting on the big story tonight from the precincts of Parliament, from where you spoke to Majority Leader Aden Duale, right?
Yes, Yvonne, and I just want to now go right to that interview. He granted us an interview just moments ago, and we got to speak to him about even those concerns that have been raised by those in the National Assembly, the motive of this bill coming at this time. Those who allege that, you know, this piecemeal legislation does not go to serve the bigger good, that what about posterity in as far as lawmaking and not serving temporal interest, as has been put in some quarters. So let's have a look at that interview with Aden Duale, the leader of Majority in the National Assembly. In the National Assembly, Aden Duale tabled in Parliament a bill that is seeking to amend the Elections Act. And he joins me now. In fact, he's invited us to his office here at the Parliament buildings and want to talk more about those amendments. Thank you for making time for us. And let's begin with what motivated these amendments at this particular time with just under a month to the repeat presidential poll?
Very, very good question, Sophie. When the Supreme Court judges, both in the minority and in the majority, gave their ruling and judgment on the 20th of September, they made certain provisions in those judgments that the legislature is called upon to do some realignment within the election laws and to do some cleanup. One of the cleanup was on Section 39, subsection 2 of the Election Act, which was invalidated as which was made unconstitutional by previous court in the minor Kiais case. So those are part of the reasons. Secondly, you remember why we are repeating the presidential elections? It's because there were too many things in as far as who won the election. I mean, from where we sit, Uhuru Kenyatta got 8.2 million votes. Former Prime Minister got 6.7 plus votes. There were issues on hacking of systems. There were issues of people didn't know where the server is. So what this law we are trying to set is that when we go to the elections, on the 26th of October, we have two systems which are running concurrent. The result transmission using the technology and the manual complementary mechanism, which the chair, given the 7 days is supposed to announce the result, can ultimately declare a candidate as the winner upon receiving the physical 34 A's and 34 B's from the 292 constituencies. Right.
Let me jump in on that, because there are those who look at it as when the judges, especially in the majority, were delivering their judgment, they talked about IEBC needing to put their house in order. They did not talk about laws. We did not hear Parliament being told there is a discrepancy or an issue here and there, so that there are those who would argue it is what the laws that were there that IEBC needed to uphold and ensure they work in that specific laws and not outside of them in terms of illegalities that the judges talked about.
Sophie, I want to be very categorical. Those who have read, like me, the full judgment in which the whole legal department of Parliament was subjected to those judgments, there were areas where the two set of judges, the minority and the majority, have asked Parliament to relook at. Take, for example, the Section 83, which we are looking at now in this bill, which was giving more emphasis to the qualitative processes of determining the winner of an election. What in this law we are saying, yes, use the qualitative process, but also use the quantitative.
So you're relying on the dissenting judgment to come up with these laws?
No, we are saying even Section 83 was used by the majority judges. It's not even used by the minority judges. So they have bit where they have picked from the minority, they have bit which they have picked from the majority. Section 39, subsection 2, which was found to be unconstitutional. And you remember the court asking, what are these streaming of results? And IBC was saying, these are statistics. We have fixed it in this bill, where we have said, for purpose of stability, the live streaming of the results must be anchored in law, so that we don't go back to the situation of the late Kivitu of 2007, where there was darkness. But we are again saying in this law, live streaming, as much as is important for the country to follow, as results are streaming in from various polling stations, the ultimate declaration will be when the physical forms are provided.
And there are those who are concerned with the physical, because they say that is taking us back to the dark days, the rigging days, where there's a lot of uncertainty and clarity, and when we talk transparency of what is going on with the forms, with the votes, as opposed to a transparent system that is electronic, where there is a footprint when you're talking logs.
Let me tell you, there's nothing like going back to the dark days. On Sunday, German Federal Republic, the Federal Republic of Germany, went to an election, and the whole of the election was manual, as ordered by their Supreme Court. There is nothing rocket science in this technology. But having said that, in this law, we are also putting a section that is saying if an election officer, a returning officer, a presiding officer, knowingly falsifies a document, knowingly alters a document, knowingly refuses to stamp a document, knowingly refuses to sign a document, he is liable to 5 years imprisonment. Right. So that we are putting a situation, as you're saying, nobody. And it's also saying political parties must also have their agents, so that the documents that are provided for under Section 72, what is called a form in law, in the chapter on provision and general interpretation of the Constitution, if you knowingly falsify a document, that document cannot be used to invalidate an election. All that we are saying is greater part of our election process is manual. And the law is very clear, and in fact the previous law said it, that the chair of IBC can only declare a winner once he receives all the manual Form 34A and 34B.
Which is what we heard one of the dissenting judges talk about largely. But let's talk about why you felt the need to legislate on the decision-making of an independent commission. When you're talking about quorum at the IEBC, talking about the powers of the chair and who can become the chair of the IEBC, why did you feel the need to have legislation on that?
Sophie, IEBC itself is a creation of Parliament. The only institution that independent bodies like IBC are answerable to is Parliament. A committee of this House called the Justice and Legal Affairs Committee is the committee that oversights the budget, the operation, and the law. So IBC, this law, they will be given the first opportunity to come before it in terms of public participation before the rest of the other stakeholders come next week and see whether these laws are okay. If they have issues with, we will amend. If they want to add more sections, we are ready. But asking me why are we interfering with that? Yes, you know, if you read the other section of the Constitution, Article 248, 249, 250, 52, general provisions for all commissions, there is a provision that says in the absence of the chair, the vice chair is the one who takes over. Now, in the IBC Act, there was a lacuna. And if you have seen even in the counties, the returning officer has a deputy returning officer who helps him even when he gets fatigued and is tired. So we were trying to do it in such a way that, because this time round we want all the Form 34Bs and 34As to be dealt with at Bomas and properly. So we have just said in the absence of the chair, even we have even gone further and said even in the absence of the vice chair, any commissioner can do their function, because for him to come and announce even the results of a constituency, like Garissa Township at Bomas, it's a function of the chair. But you have seen in the old law during Isaac Hassan's time, the commissioners were alternating. But that was removed during the joint parliamentary committee on election laws. So this is just a cleanup. We're saying if the chair is indisposed or is not feeling well, the vice chair can do. If the vice chair, secondly, and more importantly, unlike the previous commission where there were 9 members, this commission, there are only 7 members. And we have realized the quorum is 5. And at times, with the time period remaining, they have to make serious decisions. So we have always said, like any other commissions, the other commission, the quorum is 3. So we have borrowed from what goes on in other independent commissions that at any given time, if the chairman, Chepukati, has 2 of his colleagues, then he can make a decision on that pertains to the election.
There are those who are concerned about the timing and reading bad faith in these amendments and saying, why is Jubilee seeking to change the rules of the game mid-game? What do you say to that?
There's no rules of the game midway. The most important thing is it's the NASA colleagues who are asking that we must have a level playing field for them to participate in the elections. What we are trying to do, they complain about Sava being in Spain, they complain about Sava being in France, Sava being in the clouds, all those complaints. We are telling them, don't bother about Savas. The results will be announced as per the law we are making on the physical presentation of Form 34A. So I thought we were helping them.
But the question would be, you're seeking to amend laws that you made together in a bipartisan fashion with a joint parliamentary select committee. So this time around, this is being seen as unilateral.
No.
Jubilee saying that, you know what, we will not work as we did in good faith the last time. We want now to come back. And yet the agreement at the time was there would be no changes to those laws.
There is no Jubilee. What has happened today is a function of the legislature of the National Assembly. The National Assembly is a house of all parties. There are more than, I think, 21 parties. Majority of them are not parliamentary parties because they have the numbers of coalition. But from where I sit, in fact, we have not amended any of the laws that we passed at the Reform Joint Houses Committee. The only thing we have clarified is what we did in the joint reform, which was Section 44A. The use of a complementary mechanism in the event technology fails. And IBC was under obligation to gazette the complementary mechanism, which they never did. But now we have put it more clear that the Commission must tell the country 7 days, 10 days before the election, what is the system they want to apply. And we said it should be manual, that everything should be manual. So from where we sit, we are trying to make sure that level play is done, there's no lacuna in law, there's no vacuum, and that is a function of a legislature. Even me as a member for Parliament for Garissa Township, whether I am in Jubilee or not, I can decide to formulate a bill and bring it to the House.
The other concern, sir, is around these piecemeal changes when it comes to election laws, the ones we had last time, now these ones. And as the leader of majority, as a member of parliament, what do you see as these fundamental issues and what will that one fix be, if at all, so that we avoid this back and forth that appear to be more of mutilating and perhaps other interests other than posterity, which is what laws should be made for, isn't it?
There are some words which are used in this country, which I have a problem with. Yeah. Taking us back to the dark days, mutilating the Constitution. Nobody in his right senses. Every law that is brought, every bill that is brought to the House is subjected to public participation in accordance with Article 118 of the Constitution. From tomorrow, the clerk of the National Assembly and the clerk of the Senate will put adverts in the newspapers calling for the public to come and give their views. And that will be done for 7 days. The church will come, the NGOs will come, political candidates will come, parties will come, IBC will come. They might decide to disagree with this whole law and tell us, do the opposite. Parliament ultimately will do what the people want in terms of legislation. Secondly, there's nothing called mutilation. Every jurisdiction in the world, even in the US Congress, one of the functions of Parliament is to amend laws, to annul laws, to create laws. So
But every so often, sir? Every so often?
No, yes. Tomorrow, if, for example, the media fraternity feels that we need to amend certain sections of the Communication Act of Kenya, any person can write to Parliament. Because, you know, the laws we make, it's people who wear. It's a person who wear the shoe knows where it pinches. Yeah. So IBC will be given the first opportunity. They might not agree with this bill. But what we are asking this bill, in fact, if you ask me, the most important aspect of this bill is to make the next election and the subsequent elections very, very simple and manual, where Kenyans, as they vote, they are cast. Even in the courts, that the vote of a Kenyan is important. It will be counted. In court, it will be counted at the polling station, and it will be counted at the Boma Sterling Center.
Yeah. So finally, Jubilee is not seeking to bully its way around, having its way, because they are upset with that annulment of the presidential election.
We are not. We are after the annulment of the presidential elections. We are the first 2 hours to the 2 hours later, our party leader and the President of the Republic of Kenya came and said, let us go back to the people. Today he is in Western Kenya. He will be back in the city on Tuesday, busy campaigning. So we have, we know our numbers, but we want to make sure that never again will the lacuna in law be a reason for annulling a presidential election. That both qualitative and both quantitative in terms of the numbers will be important aspects of an election petition.
All right, that is the leader of majority in the National Assembly, Honorable Aden Duale, speaking about those amendments that have been tabled in the House this morning. And he says that the role of public participation will begin tomorrow and that anybody is free to start to make their views known over the next 7 days with respect to these amendments. Now, to get more reactions on that, on the big story that we are chasing tonight, is Honorable Otiende Amolo, who represents NASA and the people of Rarieda. Thank you very much for joining us on the big story tonight. I just want to start by getting your reaction to what Honorable Duale has said, which is that this bill is to cure many of the concerns that the NASA brigade has itself raised, and that laws can be amended, and that is the work of Parliament.
Thank you, Yvonne, for having me here. I have listened to Honorable Aden Duale, who's the leader of majority, and I had occasion today to speak for very few minutes on that bill. And what I told the House, and what I repeat now, is that that bill is unnecessary, it is untimely, and it is unconstitutional. I think it is unfortunate that Honorable Duale is leading the majority in the House unto darkness and carrying the country with them. This bill is actually quite dangerous. First, starting with its purposes. As you heard Honorable Duale say, he's alleging that it is to cure the issues NASA has been raising. NASA has not sought any change to law, not the Constitution, not the elections laws. What NASA has been demanding are administrative changes. In trying to change the law regulating elections, they are making a bad situation much worse. And in fact, looking at this bill and hearing the Jubilee team speak, I'm starting to doubt whether they actually desire that we work towards having an election as stipulated by IBC for now. Because if the situation was bad, it's much, much worse right now. And secondly, in saying that they are seeking to bring this bill to address the concerns that were raised by the Supreme Court, that's a white lie, and I think it's quite unfortunate. I was in court, I argued the case, I've gone through the case. There's nowhere where the decision of the court, and let's not talk of this thing of minority and majority. The law is always clear. Once the majority in a case take a position, that is the decision of the court. There's nothing like looking at the minority decision. And therefore, the decision of the court required IBC to do certain things in compliance with the law. There is nowhere where the court says, change any law at all. What the Jubilee team are cheekily trying to do is they obviously, with a lot of encourage one specifically one judge of the Supreme Court, to go outside of the issues that were presented, to comment on things that should be corrected, and it's a script that clearly was formulated before the decision was made. And now they're purporting to use that dissenting opinion. There is nowhere in the world where you can base legislative changes on a dissent. A dissent is of no legal effect.
All right. I want us to listen to the Secretary General of the Jubilee Party, who had something to say about that majority ruling. Let's listen.
What is wrong with majority? We are in the situation in which we are today because of a majority ruling. If it was not a majority ruling, we would not be where we are. We respect the majority ruling. There was an opposing ruling. There was a dissenting view from two judges, but we had to go with the majority. Now they are making majority in Parliament be a dirty word.
So he claims he's going with the majority, which was the decision at the Supreme Court.
I think the words of Honorable Tuju betrays him when he started by saying there was an opposing ruling. And that is the view they are taking. There is nothing like an opposing ruling. There is nothing like an opposing judgment. What the Jubilee team are doing, they are seeking to unlawfully use the opinion of one judge to overturn the decision of the Supreme Court. That is completely unacceptable. But if you want to know it's unacceptable, they're doing two other things. One, in the objects, they are purporting to say that these amendments are supposed to assist the IEBC in conducting the next election. Now, you heard the chairman of IEBC say they have not been consulted, they do not need any amendments to the law, and that actually any amendments can only affect their ability to conduct the elections. Secondly, it must be remembered that the legislation they are trying to change was a bipartisan legislation. In the objects, and that's a very fundamental thing, they state that this bill does not affect counties. Why do they say that? So that no one will raise an issue as to why it is also not being considered by the Senate. You will remember that the amendments that were made last year were amendments that involved both houses of parliament. There is no way you can say that at that time it concerned counties, and that is why it involved the Senate and the National Assembly. But now, in changing those amendments, they do not involve counties, so that it's only the National Assembly.
Be that as it may, some may say you're shooting yourselves in the foot as NASA by not agreeing to be part of the ad hoc committee, and as such, allowing Jubilee to have its way in the National Assembly with respect to these amendments, whether they have the majority or not.
Well, I think you know, Yvonne, first of all, that NASA has had some issues in terms of continuity in what is called business as usual attitude of the House. And that is because we take the view that although Parliament and the Executive are independent of each other, you cannot logically have a situation where you are yet to determine who has been properly elected as the fifth president of the Republic, and yet you are having the fourth president open the 12th National Assembly. And so we've taken the view that we need that matter determined first, so that the person who is properly lawfully elected as the president can then come to the National Assembly and tell us what they want to do in the next 5 years. Now, secondly, there's nothing like NASA shooting itself in the foot. As you know, the Jubilee regime, and even today in Parliament, believes that numbers is everything. Unfortunately, when you work on that belief, you lose a lot of things. One of the things you lose is the quality to listen to reason. The second thing you risk is that you risk hurrying things the way today it was hurried, moving the bill from 14 days to 1 day, and in the course of it, being in danger of enacting laws that are unconstitutional. And I can assure you, Yvonne, having looked at that bill, if it is passed, it will be unconstitutional, it will be challenged, and it will be nullified. Okay,
we have lots more to discuss with you, Otinda, so stay with me right here on The Big Story. We want to take a break, but when we come back, we'll also be telling you what somebody who has been there, done that, has to say about making amendments to electoral laws so close to the polls. We'll be right back on The Big Story.